General tranquility. Presidential Succession Health Act. Clearly, there is a need for the President of the United States to always be in good, solid physical and mental health. It is also important that all members in the line of succession be in solid health. Also, clearly, some presidents and members in line of succession have not been in solid health during the past few decades. It is thus time to correct this. This is a very complex issue, so errors are likely in this presentation. It can also be hard to follow. Unfortunately, recent history shows the importance of every little bit of this. It also shows that all of this needs to be tied together in one unit, one action, one amendment to the Constitution. Hopefully, professionals can make it clearer. Presidential Succession Health Act, Future Amendment. Given the clear need for the President of the United States to always be in good, solid physical and mental health, it is herewith a requirement that the President and all individuals in the line of succession 1. Undergo yearly complete physical and mental health examinations during the first quarter of the new year. 2. Undergo quarterly general physical and mental health examinations every quarter thereafter. Section 1. To be sure that the examiners do not undergo political, hierarchical, or other forms of undue influence. The examinations shall be done by more than one set of doctors. Set 1 shall be selected by the Surgeon General of the United States and shall act under their direction. Set 2 shall be selected from lists sent from leading U.S. medical associations. Organizations of note at the time of this amendment being American Medical Association, American College of Physicians, Association of American Medical Colleges, American Medical Group Association, National Alliance on Mental Illness, and Mental Health America. Procedure. These organizations shall be requested to provide a list of highly qualified physicians and mental health professionals. List selection. 1. Individuals appearing on multiple lists. 2. Individuals selected from the list by the Surgeon General of the United States. Selected individuals shall be requested to take part in these examinations. Set 3. Given the health of the President is of vital importance to the world, individuals shall be selected from allied nations of long standing. Allies of note at the time of this amendment being Belgium, Canada, Denmark, France, Iceland, Italy, Luxembourg, the Netherlands, Norway, Portugal, the United Kingdom, Australia, Japan, and South Korea. Procedure. These nations' ministries of health and their national medical organizations shall be requested to provide lists of highly qualified physicians and mental health professionals. List selection. 1. Individuals appearing on multiple lists. 2. Individuals selected from the lists by the Surgeon General of the United States. Selected individuals shall be requested to take part in these examinations. Allied physicians and mental health professionals shall perform at least one quarterly examination a year. Subsection 1. 1. The examined must acknowledge by signing an affidavit that the exams are being done at the aspirations of the American people. As such, all information from the exams shall be released to the general public. 2. Besides the 2 sets of selected examiners, the individual may select their own set of examiners. Subsection 2. All examiners. 1. Before the exam, they shall acknowledge by affidavit that these exams are to provide information to the public about sitting individuals in the line of succession, thus acknowledging that the exams shall be released to the general public. 2. After the exam, they shall swear an oath to the accuracy of their examinations and conclusions. Then, sign an affidavit stating that they swore an oath to the accuracy of their exams and conclusions. Section 2. When a quorum of 40% of either House of Congress, the Cabinet, the Supreme Court, or the governors of the United States do feel that the President, or anyone in the line of succession, shows signs of not being sound in physical or mental health, the quorum shall submit a request to the individual to undergo the examination within 3 days by the set examiners. they shall also submit copies of the request to both houses of Congress. And the Attorney General. Failure of the individual to present themselves for examination requires Congress to vote on impeachment of the individual within 3 days after their failure to present themselves for exam. Submissions clearly made to disrupt presidential duties could be an act of sedition. The Attorney General shall investigate the submitting and submitted parties. At the end of the investigation, they shall present their finding to Congress and the general public, with the full knowledge that failure to be fully truthful in the release could result in charges of sedition against the investigators and themselves. Section 3. All individuals running for president and vice president shall, between 45 and 150 days before the general election, undergo these examinations by the set examiners. These exams shall include items to test not only their mental acuity, but their general knowledge, including at this point of time, the Minnesota Multiphasic Personality Inventory. One of the following for general intelligence. 1. A professional level IQ test. 2. A standardized, highly used test for college admissions in the United States. To make sure the candidates understand the history of the United States. At this point of time, that would be one of the following. 1. The AP U.S. History Exam. 2. CLEP History of the United States. Failure to take the physical and mental examinations, plus the various tests, shall automatically remove them from contention/election for the offices of President and Vice President. For the President needs to be sound of body and mind and must be knowledgeable of many things, especially of U.S. history. Section 4. Any individual who disagrees with the examinations or otherwise fails to go through with them must do one and only one of the following 3 things. 1. Resign within 3 days from any position held inside the government. 2. Sign an affidavit within 3 days of the end of the quarter, stating that within 5 days they shall have the examination. The affidavit shall include the following statement. If I fail to have the exam within that time period, I shall, by this failure, be stating my wish to resign from office. They shall send copies of this affidavit to both House of Congress and the Attorney General. 3. Appeal the need for the examination to Congress, the Supreme Court, and the governors of the United States. If a simple majority of all these bodies agrees, the exam for that quarter is waived. The appeal shall include the following statement. If I fail to get a majority vote stating I need not take the examination for this quarter, or no vote is taken within 3 days of submission, I acknowledge that I shall no longer be a member of the United States government. Section 5. The only way these exams shall not be released is at the request of the examined individual. The requesting affidavit shall always be accepted and enforced under the provisions noted in the affidavit. That 1. That if they are an elected, appointed, or hired member of the United States government, that they must step down, i.e., resign, from said position within 24 hours of signing the affidavit asking for no release of the information. 2. That they never run for election, accept appointment, or apply or otherwise allow themselves to be hired by any part of the United States government. 3. The instant they fail to resign, run, accept, apply, or otherwise seek or allow themselves to be hired. 4. That said exam shall be released, along with a copy of the affidavit asking for it not to be released. Section 6. Given the critical importance of the exam, the examiner and/or examined need to know that false or misleading statements could lead to an investigation for providing false information of national importance, which could lead to criminal charges. Subsection 1. Could lead to charges of Federal False Statement Statute, 18 U.S.C. Section 1001. Footnote 1. This is the main federal law that criminalizes making false statements. It prohibits any person from knowingly and willfully making a false statement or concealing information in any matter within the jurisdiction of the executive, legislative, or judicial branch of the U.S. government. See description box for link. Under certain circumstances, this could lead to charges of false information and hoaxes statute, 18 U.S.C. 1038, foot 2. Under certain circumstances, this could lead to charges of perjury, 18 U.S.C. Section 1621, foot 3, footnote 2. This law specifically criminalizes conveying false or misleading information about an act that would be a federal crime. Footnote 3. This is the general perjury statute, which makes it a crime to willfully and contrary to such oath, state or subscribe to any material matter that one does not believe to be true. Subsection 2. Given the importance of the President's health, for the President and those in the line of succession, it is further possible for the question to be brought up before Congress, which could lead to charges of obstruction of justice, 18 U.S.C. 1503, foot 4, footnote 4, providing false information during an official proceeding, such as a congressional investigation, could also be considered an obstruction of justice. The law prohibits corruptly influencing, impeding, or endeavoring to influence or impede the due administration of justice. Section 7. Further actions against the examined, the examiner, and individuals with knowledge are possible. Under certain extreme circumstances, with extreme lies about the health of an individual in the line of succession, it could be considered an act of sedition to make a false statement. Arguments in favor. 1. One has to understand that in the past decade, we have seen obviously unhealthy individual, one cheeseburger from a heart attack or stroke announced to be in the best of health. 2. Several individuals in obvious mental distress, possibly mental collapse or dementia, were not removed from office when they should have been. 3. Huge numbers of individuals with obvious delusions as to the true nature of science, math, history, and other fields of knowledge, having repeatedly stated things that any individual with a rudimentary understanding of any of these subjects has to laugh at, have been elected, appointed, and/or hired into notable positions within the United States government. They have even been put into the line of succession. These individuals should not have ever been put in that position, and if they had been put in line in the past by accident, they would have instantly been purged from their positions. 4. To put it simply, the people of the United States should not allow idiots anywhere whatsoever in the government. 5. And people in the United States who allow idiots in the United States government are traitors to the people of the United States and its Constitution. A. Which should have resulted in hundreds of politicians and rich sycophants being imprisoned over the past decade. But that is the age of Trump, the age of the lie over the truth, the age of stupidity over science.